And also, I just want to say, I'm making a special appearance in my proprio persona.
Well, you're here, specially or otherwise, and you wish to represent yourself in this matter. When we discussed this last time, I said if you're going to represent yourself, then you need to do it right. You need to show up at the appointed time, which you have done. If you have pleadings you wish to file, you have to file them and provide a copy to the prosecutor, which you have done. So let me go through the things that you filed with the court and see if Ms. Davis agrees. You filed one of these, I think, for each case. There is one called Exhibit 1, Affidavit of Fact, Writ of Discovery for the 202073 case and the civil infraction that's attached to that. Then you filed a Writ of Discovery, Affidavit of Fact in each of the cases. Does that document require me to make any ruling or anything, or you simply wanted to have that on file?
Your Honor, and before he responds that, I don't have any of those in my files.
Or you don't?
No.
You came to the courthouse. You didn't get these?
No. He's talked about them each time he's come in, but he has not provided any to our office.
Well, some of these are printed on 11.5 by 14 paper. It's hard to find something that will print that, but I will make sure that you get a copy of each of these documents.
Thank you.
I think she put them in on base. Anyway, regarding the writs of discovery affidavit of fact, is there anything you want me to do with that, or you simply wanted to place that on file?
I had to, so everything I do, I have to place it on public record. So I let everyone know what's going on. So I basically have to anytime before court, I have to, send in my affidavit so I can let the court know what's going on prior to me being there.
All right,
so
well, I've accepted these. They've been date stamped December 1st. They're placed in the on-base filing system, and I will provide copies of each of these to the prosecutor.
But
those are on
but
file.
Also, it's my understanding.
Let me recap what else you filed. You filed a document called 1508 point, specifically mentioned identification documents 18 U.S.C. 1028, and an accompanying House resolution.
Yes.
Received that for filing. I'll provide a copy to the prosecutor. You filed a position statement of certification from the Pennsylvania House of Representatives from 1933 right to know law request. I've received that, date stamped it, and I will provide a copy to the prosecutor.
Sweet.
You provided a copy of the Constitution of the United States of America, North Continent, the preamble and the Constitution, and you also provided a copy of the Bill of Rights. We're all familiar with those, but I'll accept it for filing and provide a copy to the prosecutor. You also filed a document called Legal Notice, Name Declaration, Correction, Proclamation, and Publication.
Yes.
And sealed. And I've received that, date stamped it, and we'll provide a copy to the prosecutor. Then you filed something called United Nations Declaration on the Rights of Indigenous Peoples, 29-page document from the United Nations. I'm not sure on the date of it is 2007. And that's also date stamped December 1st, and a copy will be provided to the prosecutor. Then you filed a copy of a Treaty of Peace and Friendship dated 1787 between Morocco and the United States. And that is a 4-page copy, apparently, of a treaty from 1787. Again, that's date stamped. It's been received for filing. We'll provide a copy to the prosecuting attorney. All right, so I've accepted your filings. You wish them to be on the record, and they are.
Thank you very much.
We have some things we have to discuss.
But also,
all right, what else did you want to say?
I apologize. I wasn't trying to cut you off. But also, it's from my understanding that all affidavits must be answered, or else they stand in law, as law. I'm hoping that you all will review all my documentation and answer to my affidavit, please.
All right, let me rule on that. This is not a legal document per se. It's not a motion. It's not it's just a declaration that there is no answer. I've accepted them for filing. I'm not requiring the prosecutor to file an answer, and the court won't be filing any answer, but I've accepted your documents. So that's my ruling on that. All right, let's go through this.
But I also challenged jurisdiction from day one,
All right,
and that was never answered.
You've made your motion, and
No, it's not a motion.
all right, well, I decline your challenge of jurisdiction.
But you don't have the authority to. You have to prove jurisdiction. You have to physically prove jurisdiction with like paperwork and documentation. It's not because you just want it, and I mean that respectfully.
All right. Well, certainly they have to prove venue, which is where the crime committed at trial. But you made a motion, and I declined it, so you can appeal it if you're convicted. You've preserved these objections for appeal. Right now, you're presumed to be not guilty. You haven't been convicted of anything. You're challenging jurisdiction.
Yes.
You're challenging these things by answer. I've denied them. If you are convicted, you would have a right to appeal your denial of your motions. So I'm preserving each of your motions, but I'm denying them. But if you wish to appeal it, if the event you're convicted, you have a right to do that. So that's how that works. All right.
But also for the record, they're not motions, they're affidavits of facts.
All right. Well, okay. I'll accept them as affidavit of facts. You've preserved your objection. Now, there's 3 separate incidents where you allegedly were driving, and at least 2 of them you were speeding. The prosecutor has filed a motion to join all of those 3 cases in one trial. What's your response to that? She's saying rather than have 3 separate jury trials on this, I request to join them all for one trial.
All for one trial.
Yeah. You're entitled under the law to have 3 separate trials. One for the January 21 case, one for the November of 20 case, and one for the October or September of 20 case. There are 3 separate incidents. Prosecutor contends they show a pattern of continuing to drive without a valid Michigan license, but so she's moved to join them. But it's your right to have them tried one at a time if that's what you wish. So the prosecutor filed a motion to join them into one trial. Do you have a position on that?
Well, I definitely requested a trial by my national peers, but I know that's not going to happen. No, I don't want them all to be combined.
So the defendant objects. Ms. Davis, you wish to speak to that?
Your Honor, I stand on my pleadings as filed. I filed a motion with a brief attached acknowledging the court rule under which we're seeking this for judicial efficiency, for cost involved with these and the facts themselves. I believe that the court should join them together to have one trial. Thank you.
All right. One wrinkle to this, Mr. Morrow Bay, is if you have one trial, the prosecutor gets one shot at convicting you. You have to be proven guilty beyond a reasonable doubt. We have one trial, it's all over at one trial. If there's 3 separate trials, they have 3 separate attempts to prove the charge. So that's something to consider. However,
Understood.
I'm going to grant your objection. It certainly would be more judicially efficient to join these into one trial and do it in one day. But there's substantial prejudice if there's a trial and the jurors know that you've done this 3 times in 70 or 80 days. Your defense is essentially the same to all 3 cases, but I think your risk of prejudice outweighs the prosecutor's desire to do this in a one case efficient manner?
I see.
All right, so we'll set these all for the same day, but we're gonna only do one at a time. Now, the next thing we need
now, if I wanted to change this at a later date, is that a thing I could do, or is that just
No, I guess if you change your mind and decide, I'm gonna set all three cases for the same day. But unless you agree, we're only gonna try one case. Let's say, for example, we set all three cases and officer so-and-so is having a baby on that day. When they ask for adjourn that, we could adjourn that and try one of the other cases. And so we're gonna set all three to make sure we can do at least one. And if you change your mind and you agree to have them joined into one case, you need to tell us by a certain date. Now, Deborah, I've been looking at the dates. I've already scheduled, we lost the jury day we had set for this because Mr. Morrow Bay didn't show up for the pretrial. So we lost that date, or we'd be done with at least one of these. We've scheduled everything through January and February, which takes us to March 9th. That's a Wednesday. Mr. Morrow Bay, are you available on Wednesday, March 9th?
March 9th? I will be.
All right, I'm going to set it for Wednesday, March 9th, 2022 at 8:30. All three cases will be set for the same time. If defendant wishes to have them joined, you have to tell us by February 25th.
Okay.
Mr. Perdue, have you been provided with the dash cam video of that incident?
My name is Mr. Bay.
I'm sorry, Mr. Bay.
And I have not.
We discussed this yesterday, Your Honor, and it was, the defendant and I discussed how I would like to have some direction from the court regarding giving him this video with a protective order that he would not disseminate it or use it for anything other than the purpose of preparing for trial.
Yes, I would release it on those conditions. Otherwise, you'd be in contempt, but you're representing yourself and you're entitled to have, so video will be provided.
Yes, we have them here sitting on the staff's desk, and they did confirm an address that is a proper address for the defendant to be able to mail those out. So those will probably, if the mail hasn't gone out today, but if not, I'll go tomorrow.
Put what you want in the protective order. But Mr. Bay, you can have these videos. You can't disseminate them, share them. Put
I can,
them on TikTok. You can have them to review and prepare for your defense.
So I can't.
Right, that's the first case.
I can't show people that I was traveling in the videos, and that.
Well, you can show it to people at your house, but you can't post it on any social media. If you do, you're going to be in contempt. You can show it to people. You can't post it on any social media till this trial is complete.
Or make any reproductions of it, correct?
All right. The next case, 202653, that allegedly occurred on November 25th of 2020. That contains a speeding charge and a driving suspended charge. What's the status of that?
Your Honor, that case has not been resolved, and base says it can't connect to the servers, so I'm not sure what's going on.
John Hoffmeister, this is a Michigan State Police case.
There were two other troopers that assisted and responded, and there is a dash cam for that one.
And a driving record.
Yes.
All right, same thing, same protective order, but you're entitled to have the evidence that the prosecutor intends to introduce against you. Mr. Bay, I'd give you a piece of advice. There are a couple of speeding cases in here. The most important speeding case which sets out the standard the prosecutor has to meet. It's called People versus Ferency. I don't have the citation. It's Ferency. I'd suggest you may wish to take a look at that case. We've got Hoffmeister and two other troopers.
Okay.
Ferency. All right, then the last case, or the most recent case, is 2021, allegedly occurred January 1st, 31st. It charges driving suspended and false license. And I believe there's also a speeding attached to that. Ms. Davis, the complaining officer in that case is Jesse Raymond.
That one might have Sergeant Steers, who was in the front seat with him, if that was in the village of Centerville. And there is a dash cam for that one.
All right, so certified driving record, dash cam.
So this court doesn't recognize the right to travel?
Yes, it does.
You know what the right to travel is, right? Thompson versus Smith, the right to travel.
Right. All right, yes, I recognize the right to travel. I don't recognize the right to drive without a license and go 84 miles an hour in a 55 mile an hour zone. So you have a right to travel. You don't have a right to drive, is where you and I have a fundamental disagreement.
Speeding, driving without a license, wrong plates, no registration, no tags, etc., has all been ruled as non-arrestable offenses, and I've been arrested.
Yes.
Cal versus Farley. These are court case documents right here that we keep ignoring. I don't know why we keep ignoring these.
Well, where are
These
they
Supreme
from?
Court case documents right here.
All right.
The right to travel was ruled in the Supreme Court.
Okay, I'm familiar with it. Anyway, you didn't.
So hold on, but you can't just gloss past it though. I mean, because you have to.
All right. So you made a motion. We'll just accept it as this. I'll put it in order. Your motion to dismiss regarding the right to travel is denied. And so that also preserves your motion. You can appeal on that issue if you are convicted. So
I didn't file a motion.
Well, then file a motion if you want to argue it.
But I didn't. That's an
You can't
affidavit.
just, all right. Well, so now you're saying, so I'll accept your oral motion.
It's not a motion.
Well, your affidavit, whatever it is,
Yes.
regarding the right to travel is denied.
Your Honor, so that the court is aware, I did speak to the defendant about this issue with discovery materials and potential exhibits yesterday via telephone. But the people intend to file a motion in limine based on Michigan Rules of Evidence 403 for exclusion of evidence based on confusion or waste of time. Again, I haven't seen all of these documents that he is intending to present, but once I do see them, I suspect that we will be filing a motion in limine to have them excluded from any discussion during trial.
You have 21 days to file a motion and he has 21 days to respond.
Thank you, Your Honor.
And Mr. Bay, you also have 21 days to file any further motion.
I know. That's the affidavit I sent you. That's what it said. You have 21 days to respond to it.
I just responded to it. I denied it. I'm advised that I got.
You have to deny it in paper. You have to send me something in writing with Samir Bay on it, and you have to deny me as a national because I was traveling as a free national.
All right, I'll put that in order. March 9th doesn't work. That's Judge Patterson's day. Does March 2nd?
Honestly, I don't want to come back to none of these courts. I would love for y'all to actually uphold the law and not try to uphold these statutes against me. So I don't really choose to. The only reason why I'm even showing up is because if I don't show up, you're going to send your private mercenaries to come get me, and I don't have time for that. I have a family to take care of. So that's the only reason why I'm even giving this time of day.
It's interesting. You want me to uphold the law, but you don't want me to uphold the statute.
And no,
These aren't private mercenaries. They're sworn deputies and employed by the County of St. Joseph. Anyway, I didn't bring these charges, Mr. Morrow Bay. The sheriff's department or the individual departments filed them. The prosecutor is prosecuting them, and you're the defendant. You also wish
I'm not
to
a
represent
defendant.
yourself. So I'm going to do.
And I can't represent myself.
Schedule this. I'm going to do this for March 2nd, 2022 at 8:30. All three cases. Deborah, I would just inquire, was there a plea offer?
Your Honor, after speaking with the defendant yesterday, the people would offer that if he were to plead in each case to allowing another to violate the motor vehicle code and acknowledge the speeding violations, we would dismiss the remainder.
I'm sorry. Could you repeat that?
Sure. If you would plead to the misdemeanor of allowing another person to violate the motor vehicle code in the three open cases, we would dismiss all of the driving suspended, the registration, all of those, but you would also have to acknowledge the two speeding tickets and pay the fine for the infraction on those.
He's posted quite a bit of bond. I think there might be bond money to apply, but let's talk about what that means, Mr. Bay.
Okay.
Driving suspended is a misdemeanor. Driving suspended second is punishable by up to a year in jail. Driving suspended first is punishable by up to 93 days in jail. They both carry 2 points on your driving record, and they require that your license be suspended. This is an interesting plea offer from the prosecutor that kind of takes me a little bit by surprise. She's offered to dismiss all of the driving suspended charges for a plea to 3 charges of allowing another to violate the motor vehicle code. It's a kind of a peculiar statute. It's under the Michigan traffic code. It's found at 257.326. It's called allowing another to violate the motor vehicle code. It's punishable by a fine of up to $90 to $100 and up to 90 days in jail. This is important. It carries no points, and it does not go on your driving record. It doesn't go on your Michigan driving record, and it doesn't carry any points. I can't think of the last time I put somebody in jail for allowing another to violate the motor vehicle code, but it is punishable by up to 90 days in jail. And then the speeding charges are civil infractions punishable by a fine only. I'm going to put this in the order that that's the offer. It's a very interesting offer. It would resolve all of the cases. I guess you could plead as the other would be either Samuel Morrow Bay allowed Sammy Perdue to drive or vice versa, but it wouldn't affect your Michigan driving privileges and wouldn't go on your driving record. Just got a lot of baggage on it.
Your Honor.
Yes.
Also, the people would not object to a no contest plea in this matter.
All right. That's interesting too. Mr. Morrow Bay. No, by pleading guilty, you admit that you're guilty. By pleading no contest, you don't admit guilt, but you allow or accept that a conviction would enter. That makes this even more interesting. You could enter a plea of no contest saying, I don't plead guilty to this, but I will allow these convictions to enter for the purposes of the bargain offer. Did you post your bonds through a surety company?
I believe so.
All right, because I didn't know if I had cash or not. So I'll put this in the order and I'll put some sort of deadline in it. Let me repeat that. She offers to dismiss everything for one count of allowing another to violate the motor vehicle code.
In each of the cases.
In each of the cases.
Yes, with 3 counts.
Plus the 2 speeding counts. This will cost money, unlikely to result in a jail sentence, and it would resolve all the cases, and it would not affect your Michigan driving privileges. You could also plead no contest, saying I don't plead guilty, but I allow or accept that a conviction would enter. I'm going to put all this in a written order. I don't want to put your address out here over the internet, but over the live feed. But Ms. Davis, you've got his current contact information.
We do. Sir, the address that you gave to our staff this week to mail out things, is that still the same address?
That is correct.
Okay, then yes, we will provide that address to the court, Your Honor.
I'm not going to make you make a decision on that right now. It's a very interesting plea offer. Resolves everything. Resolves your and my disagreements on the right to travel. It results in all the cases being resolved, but nothing on your driving record other than the speeding tickets. So you can consider that, take a look at the statute, consult with people you consult with. I'm still concerned that you don't have legal counsel, but we've done fine today. You and I have been able to transact our business in a respectful manner, and that's good for all of us. So I'm going to put this in a written order. You can consider the prosecutor's plea offer, which would cost money, but would not put anything on your record but a couple of speeding tickets. Ms. Davis, is there anything else we should place on this record?
Just briefly, Your Honor, because of the trial date moving up, you had requested that the defendant notify the court by the 25th of February whether or not he would agree to join. I just asked to move that up a little bit too.
Yeah, move it up to February 15th.
And the plea offer, if you could put it in the order that it's good for 2 weeks from today. So it would expire at 5 p.m. 2 weeks from today.
All right. That would be December 16th.
Michigan time.
Yes, Michigan time. Sir, as far as notifying the court or our office whether you'd like to accept that offer, you can either call our office or call the court and set up a plea date, but please just make sure that you make contact with us if you're going to accept.
Okay.
All right, Mr. Bay, anything else you wish to place on the record?
I don't believe so.
All right, consider a no contest plea to those 3 charges plus the speedings. You can contemplate that. It would certainly bring closure to all this. And I'll send you a copy of the order, what we've done here today, in the mail. And I will.
This hearing demonstrates a classic clash between sovereign citizen beliefs and established legal procedure. The defendant repeatedly argued that affidavits, historical treaties, and the constitutional right to travel exempted him from licensing laws and stripped the court of jurisdiction, while the judge consistently treated every challenge as a legal issue to be ruled upon and preserved for appeal. The court emphasized that although citizens possess a fundamental right to travel, states retain the authority to regulate the operation of motor vehicles through licensing, registration, and traffic laws. Importantly, the judge protected the defendant's procedural rights by ensuring access to discovery, preserving objections for the record, and refusing to combine multiple cases into a single trial due to the risk of unfair prejudice before a jury. The hearing also highlighted the distinction between placing documents on the public record and presenting legally binding motions, a misunderstanding that often arises in sovereign citizen cases. Despite sharp disagreements over jurisdiction and personal sovereignty, the judge maintained courtroom order, applied standard legal principles, and even acknowledged a plea offer that would have minimized long-term consequences for the defendant.